Hello, this presentation about COVID-19 and international contract. On the 11th of March 2020, the World Health Organization declared the outbreak of COVID-19, otherwise known as coronavirus, a pandemic. By March 16th, travel and businesses restrictions imposed by governments around the world, including the UK government. The UK was put into lockdown on 23rd of March to limit the spread of coronavirus. As the virus, spreading rapidly, disrupts markets and supply chain around the world, businesses are increasingly at risk of being unable to perform their contractual obligations. Since January 2020, more than 5,600 force majeure certificates have been issued by the Chinese Council for the Promotion of International Trade to Chinese companies that have failed to comply with international contract obligations due to the virus. The COVID-19 pandemic has prompted many countries to pass a new law specifically aimed at safeguarding their public health. Some of those involved in international contractual relations will have a question of how COVID-19 impact their international contracts. Therefore, this presentation will discuss the following matters in the light of the COVID-19 pandemic. We will look at how courts decided which is the applicable law in case of international contract, and whether a force majeure clause in an international contract might apply to COVID-19 situations. Also, we will look at when a contract has been frustrated or impossible to perform. The English legal system allows contractual parties to choose the governing law of their contract, including contracts that involve foreign elements. For instance, if one of the parties is a foreign legal entity. In certain cases, the choice of foreign governing law may be restricted. For instance, agreements concerning a property that are located in England should be governed by English law. There are also general limitations to the application of foreign law by the English courts. For example, the application of foreign law may be limited on the grounds of public policy. On the other hand, the choice of English law in a contract may be restricted. The English law principles establishing that a contract governed by English law will not be enforced where the performance of that contract is forbidden by the law of the place of performance. For instance, as a result of COVID-19, countries' interventions in contractual relations, a case might come before the English courts to decide on a contract with English choice of law and jurisdiction, but with performance due in another country and prevented by enacted legislation that provide short-term relief for those unable to perform their contractual obligation due to the COVID-19 pandemic. Moving to the case of force majeure. Most contractual contracts provide for parties to be excused from their contractual obligations in the event of a serious unforeseen circumstances. Party makes the performance impossible. While force majeure clauses differ in their terms, the common thread between them is the occurrence of something unexpected and beyond reasonable human foresight. In the common law jurisdiction of England, the focus of this presentation, force majeure is a creation of contract. The term force majeure has no established meaning or consequences under English law. In order for force majeure to apply, there must be an express force majeure clause in the contract, including the definition of what constitutes a force majeure. A party seeking to rely on force majeure clause must first establish that the intervening event falls within the contract's definition of force majeure. Most force majeure clauses provide a list of specific triggering events. Terms such as disease and pandemic will likely apply to the COVID-19. Where COVID-19 is not captured by a specific term, it may be covered by broad language in the contract, such as anything beyond the reasonable control of the parties. For example, the government response to the outbreak of COVID-19 by declaring a lockdown or closing its borders to trade. Such action may fall under a definition of force majeure. There must also be a substantial causal tie between the force majeure event and the party failure to perform its contractual obligations. Whether the impact of COVID-19 on the availability of employees to perform contractual work amounts to a force majeure likewise may depend on whether company policies implemented during the outbreak, such as quarantining or remote work, were necessary, and whether in fact performance was impossible. A business seeking to rely on force majeure clause must also comply with any procedural requirement under the contract, such as a requirement to give a notice of its intention to rely on the clause to the other party within a particular timescale, including any formalities required for the service of notice. Therefore, whether COVID-19 triggers a force majeure event depends on the following: depends on the express wording of the force majeure clause in the relevant agreement, and the impact that COVID-19 has on parties' ability to comply with its contractual obligation and the relevant agreements. Moving to the possibility of frustration of the international contract. In the absence of force majeure clause, parties to the contract may be able to bring the contract to an end by relying on frustration to avoid liability for breach of contract. Unlike the flexibility of force majeure, which can be determined by the parties as expressed in their contractual terms, frustration automatically results in both parties being discharged from their obligations. However, if the impact of COVID-19 extremely changes the contractual obligations, for example in an event of government-imposed restrictions preventing travel or trade, it is possible that the contract would be considered frustrated. To summarize my presentation, the impact of COVID-19 is rapidly evolving, and there are no commonly applicable answer to the question of when can force majeure be invoked. What are the consequences of contracts? Business dealing with international agreements should review their contracts in detail and understand what the law applicable to their agreement. This will allow them to assess the ways COVID-19 are impacting their contractual relationships, including their obligation to notified counterparties of performance, will be delayed or made impossible by events beyond their control.